Hello and welcome to Legally Speaking with me Tarun Nangia. Today we are going to discuss the Hindu Succession Act, more specifically women's rights in their parents' property, in the ancestral family property. And this is all because Justice Arjun Kumar Sikri delivered a judgment in which he has stated that women have equal rights in ancestral property. We'll want to know more on this issue from our panelists. I have got with me Advocate Malavika Rajkotia, Senior Advocate Pinky Anand, and Advocate Aman Hingurangi. Thank you so much for sparing your time and joining us for this issue of Legally Speaking. We'll first start with our round of opening comments. Malavika, your opening comments on this issue.
So, this particular judgment is in continuity with many before. So, it is not something that has settled, this judgment hasn't settled anything that wasn't there already. Let's put it that way. And after all, this amendment to Section 6 of the Hindu Succession Act was in 2005. And the wordings of that amendment, to my mind, were quite clear, which is that upon the birth, a daughter is a co-partner from her birth. But the question that arose again and again over these years was whether this section is retrospective in effect or should it be prospective. And there were certain rulings. Again, some high courts ruled that it was retrospective, some said it should be post 56 and so on with various high courts. But it was finally settled, according to me, by Justice Adarsh Goyal sitting with, he was the author of the judgment, Prakashvati versus Phulavati. And in that he was very clear, which is that at the time of filing of the suit, at the time of 2005, the father and daughter should have been alive. That's number one. Now, in that continuity, so if the father died in 1980, for example, then it is not realistic, it is impractical, and it has grave consequences that are unjust to the family, to say that situations that have been settled, properties that have been settled, are ripped apart with retrospective effect by sisters who then decide to take advantage of the 2005 amendment to pursue rights or say that certain rights have crystallized to them. And the Phulavati established that that clearly was not the intention of the legislature. This judgment, according to me, however, like one before that of Ganduri, authored by my Lord Justice Lodha, is problematic. So, it is problematic in the sense that it is created, in fact, a unnecessary ambiguity on the issue of retrospectivity. In the Ganduri judgment as well as here, the father had died prior to 2005. So, considering that this judgment has come post the Phulavati judgment, I do see a problematic on clarity of law, which is undesirable.
Okay. Pinky Anand, your view on this issue?
Well, I actually disagree with Malvika to some extent. You see, the ultimate proposition in all these laws which came around, particularly Hindu Succession Act, because joint family property, ancestral property, co-partnership property has always been a source of contention because women are disinherited, excepting for a limited exception which was there. That when a male heir dies and he leaves behind female heirs, then they inherit by inheritance and not by what is called survivorship. That means the simple law of joint family property means that property normally devolves not by devolving, but by going to the survivors, so to say, whoever the remaining members of the family are. So, only males were members, females were not members of the co-partnership, so to say. So, therefore, women had no right in joint family property, and traditionally in India, we've had joint family properties up to a point of time and even more for income tax purposes. So, now we had an amendment which gave women equal rights at birth. So, therefore, from the moment they were born, they had rights. The question then always arises in all these statutes which come around whether they have to be taken prospectively or they have any retrospective effect. She is right there that the judgment said that it is prospective, Prakashvati's judgment. Now, the question arises, prospective means what? So, there I think is where the real innovation has come in this judgment, and developing the law as it stands. Till partition is finally decreed, that means you file a suit for partition, partition doesn't happen. You have what you call a preliminary decree of partition, even then partition doesn't happen. Partition effectively, if it's held to be, which this judgment holds, is conclusive when the final decree is passed, then nothing has actually happened till that point of time. Now, since in the meantime 2005 amendment had come into place in this particular case, it was held that she, as a daughter, as a girl child, had a right in joint family property on parity with male members. And I think this goes a long way, and it does not tend to reopen what is already settled. So where partition suits are decreed, the final decrees happened pre-2005, that's one chapter. And where partition suits are either pending at the first stage or even post-preliminary decree stage, then the question of prospectivity of this section would apply. And I think that's a very progressive and a reasonable view to take, because the law of partition stands on that ground.
The law of partition stands on that ground. Amaningorani, your view on this issue?
Well, I would partly agree with what has been said. The section 6, which was brought into the amendment which was brought in 2005, the spirit of that section basically is that the daughter would be a co-partner in the same manner as the son. The section itself provides that it will be effective from a particular date, and it explicitly provides that the past transactions will not be opened.
Yes.
Now, in 2016, the 2016 judgment, which was referred to by Malvika, basically said that the daughter who is claiming to be a co-partner through a father, both the daughter as well as the father must be alive as of the date of amendment in 2005.
Yes.
Because since the father's alive, he's a co-partner himself, the rights have not really crystallized. So you're not really tinkering with past transactions. Now, in the case of the 2nd February judgment of this year, which has been passed, the father had died in 2001. The court has gone on to the issue that since the daughter is a co-partner by birth, it doesn't really make a difference when she was born, so long she's alive in 2005. Yes. She is entitled to claim as a co-partner. Now, this judgment is conspicuously silent about the situation as to what happened if the father had died before 2001, because she's claiming under the father. Now, on the issue of the rights being crystallized, they don't get crystallized on adjudication. They get crystallized on the death of the co-partner.
Yes.
So, if the father had died in 2001, then there were certain transactions which would have gone as according to the unamended law, because the amendment came in 2005. Now, by holding from the gender point of view, justice point of view, it's an excellent judgment. And according to me, I wish we had laws which people understand. It's a multi-layered kind of a Hindu law, which if we go, I mean, we should actually do away with most of these laws. And the very fact that succession can be amended again and again means it's not integral to the Hindu religion. So we can perhaps simplify all this. But if we stick to the law, I'm not on the equity of it. But if we stick to the law as it is, as the section as it is, the effect of the judgment would be that whatever transactions which were concluded in 2001 on the death of the father could now get disturbed. And then the apprehension is that if this is going to be a precedent, there may be a floodgate of litigation.
Oh.
Because what would prevent a daughter who is alive post 2005 to now come and say, well, forget about when my father died.
Yes.
I became a co-partner by birth.
Yes.
And so I'm entitled to all the rights of a co-partner, and I want to file the case right now, reopen everything, adjust everybody's shares.
Yes.
No, but Phulavati has settled that. Here really the position is that the partition suit being filed prior and the decrees happened subsequent.
But my point
I
is
know,
the
but
partition
Phulavati
of
has settled the issue, will not raise the issue that you're
Precisely.
talking about.
I'm not on, you see, a person may choose to go to court, person may choose not to go to court. Adjudication is not what decides, the point which decides crystallization of the rights.
No, so to that extent, the apprehension that you are stating, to my mind, these two judgments don't give rise to that apprehension necessarily.
Precisely. My only point is, only one point is that though this is not explicitly discussed, there is no discussion on the point.
The problematic here is if Phulavati says that the father has to be alive in 2005, and here are these judgments both in Ganduri as well as here,
2001
that he
is
died
died,
in 2001.
that should be addressed. Otherwise,
it needs to be addressed as to why it is an exception.
No, that's what.
And that,
no, I don't.
thinking
No,
was-
let me just clarify. Let me just clarify one bit.
I have one issue here. In a case, there are two possibilities. Somebody dies pre-2005, let's say. Either the rights will devolve without there being any court proceedings, any litigation whatsoever, in which case the partition may happen. And not partition necessarily.
Notional
The
partition.
notional
Notional
partition
partition,
may
yes,
happen.
and their stake
all
is
the rights.
delineated,
So
yeah.
therefore, all the rights get crystallized.
Yes.
Yes.
Now, frankly, this case doesn't deal with that situation at all. So there's no ambiguity possibly on the part that you were talking about.
No, but why?
No, just for
There's
a
no
moment.
discussion, but
no,
it's
no,
not that
there
there's no
doesn't have to be.
discussion.
No. The point is, this particular case. See, every case deals with the law in the perspective of what the facts are. In this case, there was a litigation. The rights had been sought. The partition suit had been filed, and it was pending.
And
so rights had
pending
not
that
crystallized.
2005,
Now, pending
that's
that
how
2005 came. In the scenario that you are talking, if it is possible to conceive of it, in the situation where there is no litigation, rights get crystallized, then that transaction actually closes. So it well could be a different proposition to a litigation
I'd
pending.
like to-
I'd
On
like
this
to
note,
clarify this.
just 1 minute.
I'd
On
like to
this
clarify
note,
this.
before we come, I
Yes.
mean, we have to take a break. So on this note, we'll take a short break. But before we go on the break, just after the break, we're going to discuss that if the law was settled, if at all the law was settled in 2005, why you have cases coming up right up to the Supreme Court, and it takes a lot of time to come fighting up to the or contesting cases up to the Supreme Court. We'll take a short break and be right back. Welcome back. Right before the break, we were discussing why these cases come up to the Supreme Court. If at all the law was settled in 2005, I'll ask Malavika. Malavika, if the amendment settled things, why are people facing problems in common language? If you could explain.
I can't answer that because the question is people want to litigious. We are a litigious society. There is a lot at stake. It becomes a thing of let's take that chance and see. And there was some sort of ambiguity which was chosen to be read that we are talking of the rights of a daughter, and the court then in Phulavati had to say that when we are talking of a daughter, it means that it has to be in the lifetime of her father.
Yes.
And that is the clarification that was. But coming back to what Pinky said earlier and
Yes.
so Pinky's view, according to me, the way I'd correct me if I've got it wrong, is that it is not the death, as you say, which crystallizes rights on the notional partition, but it is the act of filing of the suit of partition that creates the waves. I think I have a problem with that perspective as well, because you can file for partition for rights that have crystallized to you under law upon the death of the co-partner.
Well, the whole premise,
Okay, Pinky.
whole premise of a co-partnership, whole premise of when we talk about survivorship is, the whole idea of this notional partition is that if one co-partner dies,
Yeah.
it is at that time, and now with this 56 Act, it will go either by, it goes as per what's prescribed by the Act.
Yes.
But the proper time is the death.
Yes.
Not adjudication.
Not
And
the filing,
let me just complete.
not
Let me
the
just complete.
common law
Tarun,
terms. If you
let me
could
just
clear it
complete.
for
Yeah,
us.
let him, let
That's
Aman.
Let me just complete.
Okay.
Let me just complete. I'm not saying there's a finding to this effect of what I'm saying in this judgment.
Yes.
I'm not saying that this is what the law which is laid down. All I'm saying is this aspect is conspicuously absent whether it was considered or argued, and whether that was intended consequence of the judgment also. I don't know. All I'm
It would
saying
have been
is
useful if it was
Okay.
discussed.
It
as
had
to
been
why
discussed
there
I'm
was
coming
an
back to you,
exception.
Aman, but I'll
Yes.
go to Pinky Anand. Pinky Anand, now two aspects here. Would like to know from you that if the law was settled, if at all the law was settled, why so many cases? And what are the pain points as such, or what are the ambiguities that you would like to highlight and you would like to see some clarity on?
See, laws when they are made, when you have amendments and laws, and that too in very traditional situations, particularly as a Hindu undivided family properties, and you have no rights in one cross section of people, so to say girls, and you have now rights under the amendment, you will have litigation. There is no dispute on that fact. Why the ambiguities? Where the ambiguities? The principal ambiguity, if at all, has been the date of operation,
Yes.
and the date of when the partition takes place, and the dates when the rights accrue. These are the three broad areas in which you have some ambiguities. Now, this judgment proceeds on the premise that the partition takes place when the final decree of partition is passed in a case where somebody has filed a claim.
Yes.
As in the present case, the girl had filed a case in court. It was not a case where partition had happened without court intervention, so to say. So therefore, this has laid down the law as far as this proposition is concerned, without possibly any discussion, as Aman says, on one particular aspect. But be that as it may, it is very clear on the fact that if the partition has not happened and the girl is alive in post 2005, living daughter, she is entitled to rights in HUF properties as it stands. This is the law so far laid down by the court here. And talking about why so much litigation, believe it or not, we all in this country or elsewhere also, when you have rights being given to a certain class or cross section or women, as in this case, and that is for the first time that these rights have come to you, you actually want to exercise them as much as possible. And I mean, laws never get settled till they are finally settled. So you have a stage when a law is made, and B, a stage when it has gone through a process of adjudication, so to say, for a court to actually opine on certain aspects. Three, retrospectivity and prospectivity has always a very key element in a lot of areas of
really
law.
the
So this
crux of
retrospective
it.
and prospective effect is causing a lot of
That
litigation.
that
Yes, but
is the
now
major
it's
domain.
settled.
Now
It was settled
this
in 2016 with the Phulavati
No,
judgment.
even with that, this area, Malvika, with, if it had that been settled, then this law wouldn't have gone this way. This actually creates a further proposition to this extent that it says that till the decree is passed, the rights have not crystallized.
No.
Okay, let me say.
Yeah.
You see, as a proposition of law, that the decree is final only upon the passing of the final decree, and that proposition is perfectly correct and applies not only to this co-partnership property, but generally to any kind of property in any partition suit. So that is an abstract proposition of law. Nobody is disputing that part. The only issue is that should we treat the rights have not having crystallized, or even actually, the court even doesn't say that.
Yes.
The court simply says because she is a daughter, alive in 2005, co-partnership is from birth.
Yes.
So she has a share, and just because a preliminary decree has been passed, that does not preclude her from claiming the share because the final decree is yet to come.
And doesn't deal with the fact that 2001 the
Just one-
father died.
It doesn't deal with that. That's the point.
And that is the problematic.
And let me just complete. Because here, also if you see the 2016 judgment, there also you have the similar fact situation. With the distinction you're drawing about this fact, there also the girl was saying that that as far as I'm concerned, I'm a co-partner, and the father had died before 2005. In that case, the court, it was in that context, the court specifically says it has to be a living daughter of a living co-partner as of 2005. And that entire chunk of the judgment is actually extracted in this 2018 judgment.
Yeah.
But
And
not
the result is still different.
But Aman, I want to know
and which
from
is the
you-
reason why I say that we don't know whether this was, there's no finding on it. So I won't even to say a proposition of law has been laid down in this.
No, but Aman,
for that reason.
while
No,
saying
but
so,
then what is the-
Aman,
that's the
but
problem.
the
What is the
effect, but the
consequence?
effect
I'll
of
tell you.
that could be opening of floodgates.
Okay.
No, but the point is, the judgment does proceed, and as you said rightly, the suit has been filed, preliminary decree has been passed, but the final decree has not been passed. Is
Suit
the
had been
finding.
filed prior to 2005, pending that this happened,
Okay.
and they
But
said
Aman, I want
because
to
it
know
is
from you
fluid
for
now.
our viewers that, in your opinion, what are the pain points on, because they say the final word on this law, there is no final word on any law though, but what are the pain points on this issue that you want it to be addressed?
No, the only thing I would think we need a kind of a clarification that do we go as per the 2016 judgment which says the father through who the daughter is claiming to be a co-partner.
Yes.
Whether he should also have been alive in 2005,
Yes.
or does it make a difference, or is that fact itself irrelevant?
Yes.
And she would be entitled to be a co-partner by her very birth, regardless of her date of birth and regardless when her father died. Now, this kind
According
of
to me, that clarification
So
is
I'll
not
take this as your
required
concluding
because,
comment, but
because the
we
partition suit
completely-
was filed
And
earlier.
we're running out of
And
time
so the
on this one.
proposition is on
so-
the
so
question
we're
of
running
what
out of
happened
time.
just
when
one
you
second. So
filed.
unless you make a distinction
That distinction has to be there.
this proposition, or whatever is laid on this judgment, is to be confined to the facts of this case,
Yes.
and 2016 holds the ground, then perhaps you don't need a clarification.
or
You can't have them both
you,
running.
no, you have
So
to
we'll
have
take
partitions
we'll
there is
take-
something
filed
we'll take
prior.
closing comments now. Aman Hingarani, very quickly your closing comment, then Pinky and then Malvika can close.
Well, I would say that there is both these judgments are inconsistent to the extent I pointed out.
Okay.
And hence this has led to a further flux of law, which might again increase litigation, and hence I think this controversy should be put to rest.
Okay. Pinky,
I do agree to one extent that there should be an end to interpretation. So therefore, there are two parts. What is the position of partition when a co-partner dies or a karta dies, which is the head of the family? That proposition has not been dealt with at all, which wasn't relevant maybe for this case, but is important as a question of law. Secondly, 2016 judgment does say father should be alive. So how is that to be dealt with in these circumstances? But to the third extent, the law does seem to be settled by this judgment to say partition will happen when the final partition happens.
Okay. Malvika Rajkotia, your closing comments for today.
Yeah, so according to me, both Gandhuri and this particular judgment deal with a specific situation where the partition suit had been instituted prior, one in 2001, the other in 2002, and whether preliminary decree was passed or not, as she says, the proposition is that nothing is final till the final decree. So when the 2005 judgment comes in, the benefit is given to those women because it is the filing of the suit which creates the flux from which the women benefit. I have a problem even with that proposition because according to me, the flux is created not by the filing of the suit. There is no flux. There can't be any flux. When there is death, rights crystallize and partition suits are filed to get those rights. That's all it is. That's one part of it. I have another part to this. In the process of empowering women, it is not enough to decide that they have to be empowered from parental property. Their rights have to be mirrored in the matrimonial homes because otherwise the floodgates are very often to women and wives being told by husbands to ask for their share in the parental
that's
property.
That's a good point. But on that note, I'd like to draw this
pressure.
episode to a close. Thank you so much, Malavika Rajkotia. Thank you, Pinky Anand. And thank you, Aman Ningorani, for sparing your time and joining us for this episode of Legally Speaking. The last word on this issue has not been said yet. There is much more to come. So we will revisit this issue on Legally Speaking. But that's it for now. Thank you so much for joining us.